Many are unaware that the 2023 ATF pistol brace rule has been vacated, yet the government maintains it can still classify millions of braced pistols as short-barreled rifles under the National Firearms Act. While the rule is no longer in effect, the risk to your rights remains. For braced pistol owners, this is not a theoretical issue. It concerns whether a firearm purchased legally can be reclassified as a felony offense by regulators who have already lost in court. In this episode, I will explain how cases such as Mock v. Garland, FRAC v. Garland, and the GOA and Texas lawsuit have changed the legal landscape, and why a permanent injunction against the "we'll just use the statute" approach may be necessary to protect Americans in the long term. To provide context, a stabilizing brace is an accessory originally marketed to assist shooters who require additional support, particularly disabled veterans and individuals with limited upper body strength. Unlike a fixed rifle stock, a stabilizing brace attaches to the rear of a pistol-length firearm, improving recoil control, enabling one-handed operation, and maintaining a compact overall length. For years, ATF guidance classified these configurations as pistols rather than rifles, and the firearms community relied on this interpretation. As a result, millions of Americans purchased AR and AK pistols equipped with braces, believing they were making a lawful and practical choice for enhanced control without violating NFA regulations. In 2023, the ATF introduced a new rule establishing a factoring criteria test for firearms equipped with stabilizing braces. Instead of maintaining a clear distinction between pistols and rifles, the ATF adopted a multi-factor assessment that considers weight, length of pull, optics, marketing, and whether the firearm appears designed to be fired from the shoulder. As a result, many braced pistols could be reclassified as short-barreled rifles under the National Firearms Act. Owners were given a limited period to register their firearms, modify or remove the brace, install a longer barrel, surrender the firearm, or destroy it. This change meant that firearms previously considered lawful could now subject owners to federal felony charges. When a rule affects so many people so quickly, lawsuits are inevitable. One of the first major challenges came from the Firearms Policy Coalition and others in Mock v. Garland, filed in federal court in Texas. The plaintiffs argued that the ATF exceeded its authority under the law. They cited the Administrative Procedure Act, which requires agencies to follow proper procedures and remain within the limits set by Congress. Their claim was straightforward. The pistol brace rule expanded a narrow law about rifles and SBRs to cover millions of pistols, using new agency criteria never approved by Congress. A Fifth Circuit panel indicated early concerns about compliance with the APA, setting the stage for a significant legal decision. The decision came in June 2024. Judge Reed O'Connor, presiding over Mock v. Garland, issued a final ruling on the merits. Rather than temporarily pausing the rule or limiting relief to the plaintiffs, he granted summary judgment. He found that the pistol brace rule violated the Administrative Procedure Act and vacated it. Vacatur removes the rule entirely, as if it never legally existed, rather than just halting enforcement against specific parties. From that point, the 2023 brace rule was no longer an enforceable regulation for gun owners. Mock v. Garland was not the only challenge to the rule. In Brito v. ATF, a Texas federal judge issued a broad injunction against enforcement, citing APA violations and agency overreach. The Eighth Circuit in FRAC v. Garland also found the rule arbitrary and capricious, blocking it as well. Courts across jurisdictions concluded that the agency sought to criminalize conduct beyond the statute's scope. For lawful gun owners, these rulings showed that administrative law limited the government's attempt to classify braced pistols as contraband retroactively. After Judge O'Connor vacated the rule in Mock v. Garland, the Department of Justice appealed to the Fifth Circuit in an effort to reinstate the regulation. Many observers awaited the higher court's decision. However, under the new administration, the DOJ requested that the Court of Appeals dismiss the appeal. This action left the district court's vacatur in place, effectively ending the 2023 brace rule nationwide. This dismissal, which occurred on July 17, 2025, was influenced by broader political changes, including the signing of the One Big Beautiful Bill OBBB Act on July 4, 2025, which repeals the $200 NFA tax effective January 1, 2026, shifting the focus of ongoing litigation from the brace rule to broader challenges against NFA registration requirements. In the short term, this was a significant victory, as the rule was no longer enforceable and millions of brace owners experienced relief. When an administration withdraws an appeal, There is no strong binding appellate precedent on the final merits. Mock v. Garland remains a powerful district court decision, and the other injunctions are also important. However, a Fifth Circuit opinion finding that the brace rule violated the statute or the Constitution would have carried greater weight in future cases. This is the trade-off discussed in the video. While we receive immediate relief and the rule is vacated, we lose the opportunity for a definitive appellate ruling that limits future anti-gun administrations. For ordinary Americans, that means fewer guardrails on what a future ATF could try again with a different rule text. To understand why that matters, you have to distinguish between killing a rule and changing the underlying law. When Judge O'Connor vacated the pistol brace rule, he struck down a regulation. What he did not do is erase or rewrite the National Firearms Act itself. The NFA's definitions of rifle and short-barreled rifle are still written into federal law. That creates an opening. If ATF can no longer rely on its vacated rule, it may still argue, case by case, that a particular braced firearm meets those statutory definitions, even without the multi-factor brace test. In other words, the agency can say, we don't need the rule. We can get to the same place just by the way we read the statute. We've already seen hints of that strategy. In its filings and enforcement actions, ATF has suggested it retains authority even without the brace rule. While there have been no widespread enforcement actions reported as of November 2025, ATF has maintained this position in internal communications and court filings, though it partially walked back some public statements in January 2025, clarifying that braces do not automatically make a firearm an SBR. The NFA defines rifles as firearms designed and intended to be fired from the shoulder. If a braced pistol closely resembles a traditional SBR in appearance and function, the government may argue it has always been an NFA firearm, regardless of the 2023 brace rule. This concern is central to the current lawsuit by Gun Owners of America and the state of Texas, who argue the case is not moot simply because the rule was vacated. The government continues to assert it can enforce the statute against the same conduct. So what are GOA and Texas trying to do now? They are asking the court for more than just a congratulations. The rule is gone. They're pressing for a permanent injunction against ATF's underlying legal theory. In plain English, they want the court to say you cannot enforce the substance of this vacated brace rule by simply pointing at the NFA and pretending nothing has changed. A permanent injunction is different from a vacatur in an important way. Vacatur erases the rule. An injunction clamps down on how the agency can behave going forward. If GOA and Texas win that relief, it would not only protect the plaintiffs and their members, it would also send a strong message that agencies don't get to relabel the same behavior as criminal just by swapping regulatory language for statutory buzzwords. As of October 2025, GOA filed a motion for summary judgment, expanding the challenge to the constitutionality of NFA provisions like registration requirements, especially after the OBBB Act's repeal of the NFA tax, with the DOJ under the Trump administration still defending the NFA's regulatory framework in recent briefs. All of this is happening against a larger Supreme Court backdrop. In Garland v. Cargill, the court held that ATF could not lawfully redefine bump stocks as machine guns under the NFA when the statute's text didn't clearly support that interpretation. The message from the court was straightforward. Congress writes criminal laws, and agencies don't get to expand them on their own, especially when prison time is on the line. That decision doesn't directly decide the pistol brace question, but it sets the tone. Fifth and Eighth Circuit courts have applied similar reasoning to vacate the brace rule, and the OBBB Act's changes may lead to new Second Amendment challenges at the Supreme Court level if GOA's case escalates. If ATF tries to use its reading of the NFA to turn vast swaths of braced pistols into SBRs without clear statutory language, courts now have fresh Supreme Court guidance that says, no, you don't get to stretch words like that. From a Second Amendment perspective, that Supreme Court signal is critical. Our rights don't just depend on what Congress passes or what a president says in a speech. They rely on whether unelected agencies can effectively create new gun crimes with the stroke of a pen and then salvage those efforts by relabeling them as statutory interpretation after they lose under the APA. That's why the pistol brace litigation, mock FRAC, Brito, and especially the GOA in Texas push for a permanent injunction, matters so much. They're not just cleaning up one bad rule, they're testing whether there are real, enforceable limits on how far the federal government can go in rewriting gun law from behind a desk. So where does that leave ordinary brace owners today? On the one hand, the news is genuinely better than it was when the 2023 rule dropped. The brace rule has been vacated. Courts in multiple circuits have told ATF it went too far. The government's main appeal has been dismissed. You are not automatically a felon simply because you own a braced pistol. On the other hand, the National Firearms Act is still in force, and ATF still has prosecutors and agents who may look for test cases to push the limits of what counts as an SBR. However, with the OBBB Act repealing the NFA tax effective January 1, 2026, risks of felony charges for non-registration may decrease, though registration requirements remain under challenge in GOA's ongoing litigation. The practical takeaway is twofold: stay informed about the configuration of your firearms and how your state law interacts with federal law, and support the legal work aimed at closing loopholes, not just securing temporary reprieves. In a broader sense, this issue previews future Second Amendment disputes over firearm accessories, configurations, and so-called dangerous features. If the government can lose a rule but maintain its legal theory under the statute, each victory is only temporary until a new administration revisits the issue. However, if courts establish that the statute does not extend as far as the agency claims and prohibit such interpretations, these victories become lasting precedent. The outcome of the brace cases will influence not only this specific accessory, but also the ongoing balance between the Second Amendment and agency authority. So, here's where we land. The 2023 ATF pistol brace rule has been vacated, and DOJ has walked away from its main appeal. That's real progress, and brace owners should know they are not automatically criminals just because they own the hardware they bought in good faith. But the National Firearms Act is still on the books, and the government is openly arguing it can reach many of the same results through statutory interpretation alone. That's why the ongoing push by GOA and the state of Texas for a permanent injunction matters so much. It's about locking in limits on agency power, not just winning one news cycle. Stay informed, stay engaged. And remember, a free country depends on citizens who understand both their rights and the games their government sometimes plays with those rights.